everyone present here. I am Kaur, member of Sambhav Initiative and moderator of today's session. On behalf of Sambhav Initiative, I extend a warm welcome to our esteemed dignitary, Ms. Honeyshya Raj ma'am, and to all the participants in this fourth day of 1 week online National Mentorship Program, Supreme Court Law Clerk-cum-Research Associate Examination, organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, and creating legal literacy under the direction and guidance of Patron in Chief of Sambhav Initiative, Honorable Justice C.K. Thakkar Sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Justice M.R. Shah Sir, former Judge of Supreme Court of India. Where today's session will be focused on brief preparation of special leave petition, civil or criminal appeal, and writ petition. It is my privilege to introduce our esteemed dignitary, Ms. Honeyshya Raj ma'am. Ma'am holds a bachelor's degree in political science from Miranda House and went on to pursue LLB from Campus Law Center, University of Delhi. Ma'am have had the distinguished opportunity to serve as a law clerk to Honorable Justice R. Mahadevan and have previously worked as a law clerk to Honorable Justice M. Sundar at the Madras High Court. With strong academic grounding and valuable experience in constitutional and judicial processes, ma'am bring insightful perspectives shaped by close engagement with the higher judiciary. We are deeply honored to have you with us today, ma'am. Over to you, ma'am.
Thank you so much for the kind introduction. So I'll be running across the SLP. So today's session, we're focusing on the brief making preparation. But before that, let me give you certain tips. So your part two paper will only be evaluated only when you crack your part one paper, which is very important. So I think 60% of the marks is required in your part one examination. So what most of these people or the candidates start doing initially is they focus their uh, exam preparation on the part two and they give up the part one paper. So last year, a lot of candidates who did really well in part two, they couldn't even get their paper evaluated because they flunked part one. So part one is very important. So you'll have to give your due importance to all the syllabus, whatever is the Civil Procedure Code, Bharatiya Nyaya Sanhita, uh, BNSS, the contract law, constitution law. So all these things are very important. So first thing is you'll have to prepare your MCQs very well. And then I think this year is also an online examination. Last year it was an online examination. Initially it was all initially it was all physical examinations. So right now we have moved to the online format. So first things first. So you'll have to be thorough with your basics of whatever you read. So my opinion for this examination would be it doesn't happen in a month. You can't prepare your exam for a month and then you say you can crack it up. It's not possible. So it's a process like how you have done your study in law school, or if you have been preparing for judiciary, if somebody would have started preparing, I mean, not before the judgment came, people would have started preparing for judiciary. So for these people, it'll make it a little easier. So basics have to be very, very thorough for your part one paper.
Sorry to interrupt you, ma'am. Your voice is breaking. Ma'am, you're still not audible.
So that your part two paper is evaluated.
Ma'am, am I audible to you?
I'm so sorry because there was some Wi-Fi connectivity issues. So am I audible now? Is it very clear?
Yes, ma'am. Now
Yeah,
you're
yeah,
audible.
yeah. I apologize for the technical glitch. Yeah. So MCQs are very important. So start preparing for your MCQs. Read a lot of past year question papers, and you can also start preparing for your MCQs from the Delhi Judiciary. I mean, civil judge examination ka jo bhi prelims ka question hai, you start preparing from the judge examination point of view, so it becomes a little easier. So what I would wish to talk about the law clerks MCQ or paper one exam is the questions are very analytical. It's not direct to the question, say what is liquidated damages, please answer A, B, C, D. It doesn't look like that. It is a very thought analytical. Uh, the MCQs are thought analytical. So you have to give your time and then. Am I audible?
Yes, ma'am, you're audible.
Yeah. Okay. I'm sorry. So can I just turn my video off because I think there's a bandwidth problem. If possible, I'll just. Hmm. So, so first things, so focus on your MCQs. Whatever you prepare all throughout your law school is very important. Read your contract law, constitutional law, at least the major important topics like what is fraud, what is coercion, what is misrepresentation. All these things are very important. You'll have to be very strong with your foundation, contract law, CRPC slash BNSS. It's BNS now, Civil Procedure Code Basics, and the constitution law is also very important, transfer of property act. So I think the syllabus have also been given already. So I think if you can run through the syllabus, I think you would have already conducted a session. I'm not diving deep into it. Let's so this is what I have to talk about before starting on the brief preparation. So part one examination is very, very, very important. So kindly give your 50 to 75% of your time when you're preparing for this exam should go only in part one. Part two becomes quite easy because I'll take you through. And then I think by this end of the session, I think you guys will be able to start doing part two very well. So you don't have to focus much on part two, but cracking part one is only very important so that your paper is evaluated. So I'll tell you part two examination here is for 300 marks in total. You have 3.5 hours time for this paper. Now, this three questions part two examination as. The very first question is the brief preparation, which we will be talking about now. The second question is your research based question. And the third question is your uh, the GK based question. Now, the very first question is brief preparation. It is for 150 marks. That's like almost 50% of your paper two, which is why it is very, very important. Second, research questions for 75 marks. And the third question is also for uh, 75 marks. Now, before talking about brief preparation, you will also have to run through your live law every year, every day. And live law also has a lot of digests for each and every law, like half yearly digest is also there, yearly digest is also there. Yearly digest in CPC, CRPC, Transfer of Property Act, taxation, everything is also given separately. But I think for this examination, instead of reading the entire digest completely, I would request you guys to read the landmark judgments of the Supreme Court in the last year. So there is also a live law ka page if you guys have access to live law. Otherwise, please buy one. Or I think Bar and Bench is also good. So either of these two websites you guys may follow and then start reading the latest updates, the Supreme Court judgments, the High Court judgments. And whenever we talk about the latest updates in law, it does not restrict only to case laws. You don't have to just remember the case laws or what, but you should also be aware of what is happening in and around Supreme Court. So that is quite important. The questions are not very simple, like, what did this judgment hold, or what was this ratio? In which case was this ratio held? It's not like that. But instead, they may ask certain analytical questions, like, say, there'll be one judge who has given a lot of dissents sitting from the Supreme Court of India. So you'll have to be able to answer that. You can be able to answer that only when you follow live law news every day. So that's very important. So sometimes like how many members does the collegium consist, who all are part of the collegium presently. So these are the latest. You'll have to be updated with the law, what is happening in the Supreme Court, across the high courts, what is happening. Everything is very important. Apart from this, let's jump into um, paper two, brief making, which is the major objective of this section. When we're talking about SLP, so brief making, there are four formats right now, majorly in Supreme Court. As I hope you guys are aware of the Supreme Court jurisdiction, I don't have to take you through that, I believe. But let me put it simple. Very first thing which we are dealing with, most of the cases in the brief preparation, what the questions usually are asked from SLPs. SLPs are special leave petitions. These are filed under Article 136 of the Constitution, the special leave jurisdiction. Now, SLP can arise from either of the courts. I mean, any order can be challenged under SLP. It's not only the orders from the high courts have to be challenged before the Supreme Court. It could be a order from a district judge, Saket. It could also be an order from Munsif Court. So there's no direct, there is nothing mandatory that uh, the SLPs have to be arising only from a high court. This is the first thing. SLPs can come across from any court, any court. This is the major thing. That is what is called as Article 136, special jurisdiction. If you read the article very properly in verbatim, it says from any court, so which is very important. So running through the basics of SLP. So first thing, it can come from any court, and then there's a specific format according to the Supreme Court rules. Uh, where you file an SLP. So I hope once I run the format to you guys, you will be able to grab it easily. What many people miss is people don't know how to read an SLP paper book. So people might not know where is the impugned order. People might not know what is impugned order. People might not know what is an annexure, who are parties in this SLP. These are the basic things. Because of which a lot of time is wasted in your exam figuring out where are the parties, who is the present party before the court, who is the respondent before the high court. All these things people start missing out, and they spend around like 30 to 45 minutes only figuring this out in the examination. So I thought I'll run through a basic SLP. I mean, I'll teach you guys how to read an SLP format where you guys will be able to quickly do that in the exam. The very first thing, I'll just share my screen. Let me know if it is visible for you guys. Yeah. So the SLP format is actually given in Order 21, Rule 3 of the Supreme Court Rules 2013. So there are four types of questions you guys can expect. The first is the SLP format. The second thing will be your civil appeal. Third thing is your criminal appeal. And fourth one will be your writ petitions. So SLP and SLP has a different format. Civil appeal and criminal appeal will have a different format, and writ petition will have a different format. So I'll teach you very briefly how each one is done so that you guys can make a note of it. And once you guys make a note of it, it'll be very easy for you to navigate in the examination. So this is a basic. So certain people might have prior internship experiences where they would have drafted an SLP, where they would have worked with another lawyer, or they could have done a judicial internship where they would have got the note making skills already available with them, or they know how to make an SLP. But this session, I'm treating it as basics for everybody so that everybody knows. So let me start from the basic. I'll just share my screen. I'm just using the I'm using the Supreme Court sample answer key or the sample question so that it'll be easy for you guys also to follow it up. Is my screen visible?
Yes, ma'am. It was. Yes, ma'am. Now it is visible.
Okay, okay. So let me share across this. This is how an SLP looks first. So before all that, last year, I'll tell you what exactly happened in the last year online examination. So last year online examination was first time in the online mode. So that last year was the first time they conducted an online mode. But then your SLP paper book or the question will be available in the online format, but you were required to answer it physically in paper and pen. That is the first thing. We don't know whether it will be done through the Microsoft Word this time or whether it will be through paper and pen, but it's usually through paper and pen test, but the question will be available in the online format. So last year, what exactly happened is there was no page break in your SLP paper book. There was no proper line spacing, no para breaking, and there was a lot of malfunctioning and there was no bookmarking. So with bookmarking, what you'll be able to figure out is, okay, this is the impugned order, this is the SLP, this is where the annexure is. But here, with respect to the online format, there was no bookmarking, and it's very difficult to navigate with the SLP paper books. So right now, I'll make it a little easy for you. So be prepared for any of these technical glitches or the improper formatting of the SLP the Supreme Court does during an examination. So first things first, let me run through you an SLP. My screen is visible to you. So this is how an SLP paper book looks like. This is the first question. This question carries 150 marks. And for your paper 2 to be evaluated or for you to pass this examination, you need at least 60% in your paper, 50% in your paper two for your paper or your ranking to be considered. So 50% is 300 you'll have to take at least 150 marks. And this question can be easily, this is a very scoring question because all your content is given to you and all you have to do is organize it into a particular format and then give it. So 150 marks, you don't have to study specifically for this question alone. So this is a highly scoring question compared to your question number three. So question one and two are easy scoring. So question one is very important. If you fail question one, I think I will tell you, you will fail your examination. So,
Uh,
so question one is
sorry,
very
but
important.
ma'am, your screen is not visible, ma'am.
It's not visible.
No, ma'am.
Okay, I'll share it. Now it's better.
No, ma'am. Uh,
Now it's okay.
yes, yes, ma'am.
Okay, okay. So, so this is how an SLP paper book looks like. You call it a paper book, first of all. So these are the parties. Sometimes what happens, the name of the parties, it could be Ajay and others versus Suresh and others. Okay. So we'll first things first, we'll just run through what the Supreme Court expects. Supreme Court expects how a evaluator would expect from your brief. So then I'll be able to run through you the SLP. The first thing they would look into is whether you're able to identify relevant facts from the SLP, identify the relevant issues. Third thing is whether you are able to analyze the issue, which is how the issue is analyzed in the impugned order, the trial court order, the first appeal court order. And then you'll have to talk about what are the grounds of this SLP. And then any SLPs will have a crom and prayer. That is special leave to appeal. That will be the prayer in any SLP. But it would not be the case for a civil appeal or a criminal appeal or a writ petition. So the prayers for the four things would be different. For an SLP, it's a common prayer across all the petitions. Now, first things, how do we see the SLP? So first thing is, this is how you have, this is the initial, this is how the index is there, the table of content. You have P1,
Ma'am,
P2, there
screen
might be
is
multiple
visible.
annexures.
Ma'am, screen is not visible again.
Sorry. Okay. So this is the table of contents with the index. So index will contain annexures. It's very important how many other annexures are there. You guys have loved to read it. The Supreme Court usually will restrict you for an SLP for not more than 150 pages. But at 150 pages, yeah, 150 to 150 pages will be normal. So there'll be multiple annexures. The very first thing what you find in an SLP is an office report on limitation. Limitation means this is where the delay will be given. So the very second line, there are two things. One, there is a delay in filing, and there's something called as the delay in refiling. So once your SLP is filed, and then you have another 30 days for you to refile these present SLP after technical defects. Or so I'll tell you the process also. So 90 days is the time period for you to assail any impugned order before the Supreme Court. So after 90 days, how many days it takes for this particular person to file an SLP is the first part of delay. It could be 25 days. Say, for example, 25 days, there is a delay in this first petition. And after 25 days, once you file an SLP, the registry might put it on defects. The defects could be for certain reasons. Say, for example, certain pages were not valid, certain pages were not annexed, certain translations weren't improper. Could be multiple reasons. And then you have 30 days time to rectify the delay. So that is called the refiling. You call it refiling. Initially, you will have something called as the diary number. Here, the SLP number is not given, but initially they'll be giving you something called as the diary number. Once you file an SLP, when there is no delay, you get an SLP number. But whenever there is a delay in your SLP, you'll only get a diary number. You won't get an SLP civil number. Only when delay is not the delay is condoned, it will be changed to a civil number. Okay, so delay is very important in your question. You should be able to highlight how many. The very first thing which you do is write the delay in the number of write the delay in filing or refiling of the SLP. That's very important in this question. So you should. This is why this page is also given. It is very important for you to realize it. And this is the particular date of filing in SLP 23/7/2022 in this particular case. Now, after your office report, you have something called as the listing pro forma. Listing pro forma is very important because these two things in listing pro forma is very important. It gives you a basic idea of what is this particular SLP talking about very broadly, and then it talks about uh, basics. So here, if these two sections are very important, we'll come back to it later. If I don't come back to it, just remind me. Similar dispose of matter with citation of similar pending matter. Sometimes this SLP might be, say, for example, from the same impugned order, two people would have filed an SLP. So, if in a certain case an notice is issued or if the case is pending, you should highlight it in your briefs as well. It will give you extra marks. Most of the cases in Supreme Court examination, I don't think so. This part is usually given or the question is tested here. But please make sure if any other number is given, make sure you write similar matter so and so is also pending before this court. You'll have to go through this as well. In criminal SLPs, usually this listing pro forma becomes very, very important whenever you're given a criminal appeal or a special leave petition criminal. I'm talking about special leave petition bracket criminal, not special leave petition bracket civil. Whenever special leave petition bracket criminal is given, these things become important. A, B, C, D. So A is whether the accused is convicted or surrendered. You should know whether the party, the accused, is surrendered or not. So which you'll be able to identify from your listing pro forma. So as with respect to the period of sentence undergone, even if it is a simple bail matter, you should know whether the accused is in jail, for how long has he been in jail. All these details you'll get only here. You don't have a separate certificate, or somebody might not even raise it in their SLP grounds. So these listing pro forma becomes very important. So A, B, C, D. B and C will usually be there in the list of dates, but D, E, A, D, E. This is where you get the content. Okay, so listing pro forma becomes very important. So please do not leave or skip the page in your examination. Read through what it is. Now, after all this, the very first thing you have, this is called A. This is how a SLP paper book looks like. This is usually named as A. It's not given here, but it's A. And then you have B. B is synopsis. Okay, this is not the page number. This is, sorry, leave this page number. There won't be any page number. Synopsis usually starts with B. And then the next page will be C, D, E, F. That's how it runs. Okay. Now, and page number 1 in any SLP will be your impugned order. Page number 1 in any SLP will be the impugned order. I repeat, page number 1 in the SLP paper book will be your impugned order. So don't go figure out where is the impugned order during your examination. It is there immediately after synopsis. There's something called as a list of dates. And after list of dates, you have something called as the impugned order. Let's see what is a synopsis. Synopsis is usually what is this present case talking about. Synopsis and list of dates is very common in list synopsis, list of dates, and impugned order. This is common across the SLP, civil appeal, criminal appeal, and writ. It's very common. So this is how the usual formatting of the Supreme Court goes like. It's under Supreme Court Rules 2013. This is the particular format. Now, synopsis, they give you a brief background of what this particular case is about. Here, they just read it as Article 136, arising out of the impugned order dated 8/1/2022 from the High Court of Madras, second appeal number. This is the case which is being assailed. And then there, the same thing was dismissed. And then here it is a very small synopsis. But usually synopsis might be for another 2 or 3 pages. It's usually said whenever the synopsis is actually a good content, you'll be able to understand the SLP very easily, and then you'll be able to make an easy format. Sometimes the format is very bad. So, like in this case, it's very 2-3 lines where they don't even give you a brief background of the case. In certain cases, synopsis, they give you a detailed background. So this is synopsis, and then you have something what is the list of dates after synopsis. So, list of dates, what is list of dates? They give you a brief background of what is the entire dispute about with the dates. Now, here they talk about petitioner is so and so. I'll run through the SLP and then I'll teach you how to make briefs. So this is, so there they say the petitioner is the defendant. So your party here, the petitioner in this particular SLP is the defendant in this case. So you'll have to name the particular party as petitioner/defendant instead of just writing P. Petitioner is not plaintiff here, petitioner/defendant. And the respondent is the plaintiff in the lower court, right? So respondent/plaintiff is how you name your parties. This suit is for permanent injunction with respect to the suit property. The suit property is defined in Annexure P1. So, guys, please listen to me. You will have to read the annexures whenever you write the examination. Annexure reading is important here, or even if you guys get a judicial office and join there, and then if you are required to make briefs, annexure reading is very important. Now, this is the list of dates. It gives you a brief background. For example, it might say when the property, if this is a civil case, it will teach you how, when the particular property was bought, when was the agreement to sale executed, when was the sale deed executed, how much, when was the date for specific performance, when was the date of cause of action arising, when who filed the suit first, before whom, which court, and then after that, what when is the decree of the trial court, all, and then after the trial court decrees there, when was the first appeal filed by whom, and then when was the first appeal judgment coming out, and uske baad, after the first appeal judgment is done, and then you talk about the high court appeal, who filed it before the high court, and then who got it dismissed, I mean, when was the appeal dismissed or allowed, and then you'll also have the date of an SLP being filed. There might be another multiple more dates inside, but these are the major important dates in the SLP format. Now, so this is exactly how the case looks like. See, I've told you this is the date of decree, agreed, who has filed the appeal, and
Sorry,
after that,
your screen is not visible again now.
okay, so here is where you will find who are the parties, what was the suit filed for. Say they got the agreement executed, Vide registered, sale deed dated 16/2/2000 for 27,000 rupees. Enjoyment of the suit property. The cause of action has arisen, and these people have filed a suit before the court. And then the summons was issued, and the written statement was filed by the respondent or plaintiff. Sorry, respondent petitioner here. And then the date of the decree of the trial court. And then you also have the appeal, first appeal. First appeal is before the principal district judge Rohini here, called the first appellate court. Who filed it is also given. The petitioner preferred AS. And then again, the same was dismissed. The order is in annexure P2. And then the petitioner, because of the dismissal, agreed. He filed the second appeal before Madras High Court. Madras High Court also dismisses the case with the impugned order dated so and so. And then you have the special leave petition. So this particular case is a very easy case where there is three concurrent findings. Trial court also dismisses the suit. Sorry, trial court is in the favor of the respondent, so it allows the suit. The first appeal is dismissed. Second appeal is also dismissed. Right. So this is concurrent against the petitioner here. So immediately, as I told you, page number 1 will be your impugned order. Page number 1 will be your impugned order. This is your impugned order. And then after your impugned order, you'll find the parties or the SLP. This is called the special leave petition. This
Ma'am,
particular few
it's not
pages.
visible, ma'am.
So this particular pages are your SLP. Okay. So SLP has 8 facets. The first things first is who are the parties. There might be multiple parties. As I told you, it could be Ajay and others and Suresh and another. So you'll find who's petition number 1, petitioner number 2, petitioner number 3, petitioner number 4. It could be multiple petitioners and multiple respondents. You can find it only in this particular page. This you will find it after the impugned order is done. So for example, if this is page 24, you'll find it in page 24. So only when your SLP paper book will have the position of the parties and who are the parties before this court. So instead of searching it anyway, you should jump into the parties and then start with it. So this is where you find the this thing. So as I told you, 8 facets of an SLP. This is one against which order the present SLP is filed. Second thing is something called as the questions of law. So SLP can be admitted only when there is a substantial question. I mean, like you have section 100 second appeal here also only when some question of law is there in this particular case will the SLP be admitted. Otherwise, not in every case, every other, it cannot be treated as an appeal jurisdiction. It's a special leave to appeal jurisdiction. Only when you get an appeal, leave to appeal will you be able to assail the particular matter here. So the questions of law are given here in number two. And then you have the declaration 3 and 4. So this declaration is very important. So sometimes what might happen is somebody would have filed an appeal against this same impugned order already, and the court might say, like when in the very first time, whenever you file an appeal against the same impugned order, the court is like go before the high court, get the matter reviewed, and then come back to this court. So there might be multiple SLPs which could be filed from the same impugned order. So just to read it, whether if it is the same petition or some other petition has also been filed already. So this is very important. And this is declaration where all the things are true and then everything is the next year. And this is grounds. Grounds is very important. This is also, which is very relevant for your examination. You'll have to take the grounds for whatever your SLP or brief preparation is from this particular grounds. And after your grounds, you have grounds for interim relief. And then you have your prayer. As I told you, all the SLP prayers will be same. Grant special leave to appeal against the impugned order or pass any other order. And then you have something called as prayer for interim relief. Sometimes the courts might contain, I mean, sometimes the SLP paper book questions might contain prayer for interim relief, or sometimes it might not. So you'll have to just think about it whether it contains both. If there is a prayer for interim relief, then you'll have to mention that prayer also. I'll take you through when I am running through a brief making. So this is how SLP paper book looks like. After this SLP, you'll have something called as this appendix. This is not there in this particular case, but there's something called as appendix. So, for example, whenever a matter is coming from a state law, say, for example, Kerala Municipal Corporation Act, then that particular act might not be available with the Supreme Court. So that's exactly the reason why these people annex the local laws within your paper book so that you will be able to read it. Now, after that is done, you'll have annexure P1, P2, P3, P4, P5. It goes on. How many ever annexures are there, it will be annexed there with. And you guys will have to read the annexures. Without reading the annexures, you'll be unable to attend this question or pass this examination. Now, as I've taken you through the how an SLP paper book looks like, do you guys have any doubt how an SLP paper book looks like so that I'll just answer that question and then maybe I'll teach you how to make briefs from this after this. Okay. So anyway, I'll just start teaching you how to make briefs now. I'll show you a sample brief. This is how a sample brief looks like. First thing, you'll have to identify the parties. So, for example, Madhav Hari and Sathale versus Sarubhai Phandari Patil are the so the very first thing in a brief should be your SLP, civil diary number, so and so. Or if there is no diary number and if there is a civil case number, then you'll have to mention it if it is an SLP civil number. Otherwise, you'll have to mention it as diary number. The very first thing is your title.
Your screen is not visible, ma'am. The sample is not visible, basically.
Okay, now it's better.
Yes, ma'am.
Okay, so you'll have to write this SLP civil diary number is important. This is the first thing which you'll be writing in your um, question, which the title. So you'll have to identify whether it is a diary number or a civil case number. That is very important. If it is a civil case number, you write it like this. Otherwise, you write it like this. And then you write what is the parties? Who are the parties? Madhav Hari versus Sarubhai Phandari Patil. Sometimes, as I told you, it could be multiple parties. So you start writing as P2, say Suresh Kumar, P3 Ajay Kumar. Otherwise, there might be multiple respondents, say, for example, state of Tamil Nadu. For example, I'm just showing you. R3 could be manager, SBI. I'm just giving you an example. So you'll have to mention all the parties so that the judges or the evaluator will also be able to identify whether are you running through the SLP properly, and you'll be able to identify who are the parties to this present case. So the name of the parties is very important. You'll have to mention it in start. Okay. Who are the parties are very important. Identifying the parties, the title, and then your head note is also there required. Head note is your SLPs challenging the order or judgment dated what in application number so and so what by which court the SLP is arising out from which court and what exactly happened. So this is called the head note. It should be very short and it's usually done once your entire brief is prepared. It's usually done, and then you can put the factual background or the brief background of the case. I'll run it through this. So in this particular case, the Supreme Court is given a particular format, but I'll teach you another format which will be very easy and could be highly scoring for your exam. So usually, so identifying the parties or the head note is very important. Writing the position of parties is important, and then you write the brief facts. Brief facts, or you can write it as brief background, and you can introduce the case. You introduce the case in the sense what exactly happened in that particular case. For example, here I am writing, so petitioner is the owner of the land, measuring so and so in property so and so. So this usually in this question, what exactly they've done is they've stated the property to be referred from annexure P1. So you'll have to go to annexure P1 and then pick out what is the suit property and then write it. And then after this, you'll have to say the respondents are in possession. And then respond property of R is on the western side of the property owned by petitioner. Petitioner approaches his land through so and so way from which side of the boundary. So this dispute is initially a easement dispute or the right to wait dispute. So I'm just giving you an example. And then you'll have to write this is the background of the case. And then you can introduce the entire facts of the case in your factual background. And after your factual background is there, you'll have to write what is the cause of action for this particular suit. So, for example, R might have a different case in a civil appeal. I mean, the plaintiff will contend a different case, respondent will have a different case. Sorry, the defendant will have a different case. So plaintiff's case, you can figure it out from the plaint. If there is an annexure given in your SLP paper book saying copy of plaint dated so and so, filed by so and so, please refer to that annexure P1. You get the entire history of the case from that particular plaint after your LOD. Once you're done reading the LOD, please refer to the plaint. You'll get the brief background of the dispute. And once you understand the plaintiff's case, the next thing you'll have to do is to figure out what is the defendant's case. In any civil dispute, this is very, very important. So, defendant's case, you can figure it out from his written statement. Okay, so you'll have an idea. So, in the brief background, you can put the case of the plaintiff is so and so, cause of action arose so and so. That is this suit is filed, and then you write respondent instead contends that this particular property belongs to him because he would have got it to somebody. Everybody has their own case for justification, and that's exactly why these people are coming to court. So both of us will try to justify in our own way. So how these people would have justified their case would have been given in the plaint or in the written statement. And after this, the cause of action given, there is a suit filed. And then what exactly happens? You'll have to look into the prayer of the suit, or it could be a petition, it could be an application, it could be anything, but you'll have to look into the prayer of the trial court plaint, or it could be an application, or it could be any other thing. You just have to look into the prayer, and that prayer is very important. It could be a temporary injunction, declaration, uh, specific performance. It could be mandatory injunction. It could be recovery of possession. It could be anything, right? This is in a civil case. I'll teach about criminal case in just after 10 minutes once I'm done with this. And after plaint and written statement, you've gone through this, you'll have to go to the annexures. Annexure, you'll have to read the annexure. Annexures are very, very important. And whenever you do that, you'll have to write the list of dates. When was this plaint filed? When was this filed? When was that filed? You'll have to do that. And then the trial court decree is passed, or what does the trial court do? Who filed civil suit? P filed civil suit praying for declaration injunction, restraining so and so from causing obstruction to road passing through the southern bunch before civil judge, second division. So this is the trial court. And then trial court allows the suit holding that is not binding, however, injunction wasn't granted. So you'll have to whenever you do the briefs, page numbers and annexure numbers are very important. You'll have to write where have you taken this particular annexure from. So I would suggest you to do it through a list of dates format. After your background, introduce your background to the particular SLP. You can start the dates and events column. The dates are important, events are also important. What are the major events happening? You can highlight it in your dates and events column. In your paper pen also, you can just put a column date and then write about the events. And then once the trial court decrees the suit or allows the suit or dismisses the suit, you have to do the findings. Findings means why did the trial court do this? Why did the trial court allow the suit? Why did the trial court dismiss the suit? What is that some important thing which the trial court finds because of which they have arrived into a particular conclusion? So there also you'll have to write, and in every finding you'll have to write the para number and page number. Para number and page number. Say for example, you'll have to write this paragraph number 23 at page number 24. Every some trial court orders may not have a para number. Some trial courts might contain page, but every page there will be page number for everything. So for every finding, you'll have to have the page number. See here also page number is very important. Annexure P1 and page number so on. So page number, para number is very important. That itself carries like some 10 marks or 20 marks. So para page number is very important. Apart from that, you have filed an appeal. Who files an appeal again, as I told you earlier? So where is this particular thing? It's in annexure P4. Which page number is given? And again, findings, para number, page number is important. And then the second appeal is filed. Impugned order may what happens? Impugned order is something which you guys have to read it in complete word by word. What exactly happened? Everything. And then SLP file. Say for example, 23 to 2022, 25. Then you write SLP file. And what are the grounds of an SLP? You'll also have to write ground A, ground B, ground C, ground D, everything. You will have to find relevant grounds. There might be 25 grounds, 30 grounds in a particular SLP, but you don't have to write all the grounds. All you have to do is important grounds which you think would make sense in this particular example. For example, in the sample brief, there is M tuck grounds, but you don't have to write all grounds from A to M. You'll have to find out 4 grounds or 5 grounds which are very important or which could lead for this particular case to be notice to be issued in this particular case, identify those grounds and then start applying it. And after that, as I told you, prayer is very important, and prayer is special leave to admit. Whenever an interim relief is sought, you'll have to write an interim relief. What is the interim relief sought? And apart from that, you'll have to write how many days delay in the petition is very important. Okay. So this is how a civil SLP looks like. There might be criminal cases. So criminal cases mean what you guys will do usually is I'll going to share the format for criminal SLP. So criminal SLP is usually any criminal SLP will definitely contain an FIR, right? So instead of using a brief background to your brief, what you can do is case of prosecution. That's how you can start with. Case of prosecution means what is the FIR actually alleged or what is the case of prosecution per se, but very important. Okay, so you can start with case of the prosecution, put your list of dates and events column. So for example, brief background of what the FIR holds, you can put it in case of prosecution. Whenever you do briefs, make sure page number and para number is very important in everything. And you put it a separate column or you can just write it along with, but page number, para number is very important. And case of prosecution ke baad you write, it could be anything. It could also be a criminal appeal. They might ask you a criminal revision petition. They might ask you a lot more. I mean, a lot of varieties are there in SLP criminal, but I'm just giving you a brief idea. Just give me a minute. I'll just. Or it could also be a bail, but usually bails are not asked. They usually ask you a proper. Let me share a format. Is my screen visible?
Yes, ma'am, it is visible.
Okay. So this is how again SLP diary number criminal. What is the case title? And then you have to also note down in one line. Maybe you can also note down what type of case it is. It could be an appeal against conviction, or if it is an appeal against acquittal, or if it is what. Okay, so you can just give us a head note for the judge to understand in the very initially what is the case about, whether it is gang rape, it could be a murder, it could be check bounce case, dishonor of check, or it could be forgery. Just have to write it in the title and what is the sentence. This is in a SLP criminal format. Again, the head note similarly, whatever applies to SLP civil, same thing happens here. You have to be very crisp. What does the High Court hold? Whether it is a conviction, whether the trial court judgment was upheld. Is my head note making sense to all of you? SLP filed against judgment dated by High Court in criminal appeal, wherein High Court dismissed the appeal, thereby upholding the judgment, convicting and sentencing them for so and so years. So remember, I've told you that in the listing pro forma, you'll have to look into the similar matter cases pending or not pending. So whenever there is a similar matter case pending, you can put a note like this. In the similar matter, if there is any case, they would have given you the SLP diary number. And you'll also have to write what is the title and arising out of what exactly happened in that case. You can make an extra note of this if there is a similar matter. This will actually help the court in deciding the case in entirety. Even if the niche parts are not there, but if only this particular note is there, the judge might consider an issue notice or not issue notice. As I told you, the basic thing, like in a brief background for a civil case, what is important here in a criminal case is your case of prosecution. Case of prosecution is FIR. What is the FIR hold in basic? So exactly whatever is there in the FIR, you'd have to put it in crisp, very, very crisp. There might be multiple accused in a particular FIR. There might be just one accused. And if there is only one accused, if there are multiple accused in an FIR, and the petitioner is only say accused number 5, you'll have to mention it as petitioner slash A5 in the initial stages itself, and then you'll have to mention here whenever if this case was relating only to A11, so I mentioned everywhere A11, A11, A11. Understood? And once you give the case of prosecution, what exactly happens after it? Whenever it is in a criminal trial, so a criminal appeal, there is conviction, and then there is appeal against conviction or acquittal, and then you have your impugned order. This is the normal process. Sometimes in a criminal revision appeal, so for example, your 313 statement is to be called, the accused is to be examined under section 313. Then you go before the court. The accused may not be given a proper chance. Sometimes some discrepancy would have been there as part of the trial, because of which an impugned order is passed, and against which they might go on a revision before the High Court under Section 397. And the impugned order is passed under revision, and then the SLP is filed against the revision order. But these are the cases they may not ask, but they may restrict you to criminal appeals in basic. So criminal appeals means there's conviction or acquittal. Now, so you'll have to mention the date when the particular person was taken into arrest and taken to custody. This is also, you will find it in the listing pro forma or sometimes from the list of dates. And then you'll also have to mention here when was the additional district judge, what is he old, whether there was conviction or acquittal, what is the type of sentence, how many sentences given. And annexure page number is very important. For every finding, there is a page number, very important, as I told you earlier. Every finding, para number, page number is very important. Who filed an appeal and what grounds did these people file an appeal is also very important, which is the impugned judgment is very important. Para number, page number is very important, as I told you everywhere. This is very, very, very relevant. Now, and then you have an SLP. Why is it filed? What are the grounds? As I told you, 3 or 4 grounds is important. Interim relief is also required. As I told you, period of sentence undergone whenever in any criminal appeal or SLP civil criminal, SLP criminal matters, you have to write what is the period of sentence undergone. Correct? So this you find it only from the listing pro forma. This you find it from the listing pro forma. Don't forget to mention this. This is very important. Okay, this is exactly how they evaluate you. So this is SLP criminal. Now, as I told you, SLP civil is done, SLP criminal is done. I'll run through you the writ petition. Writ petition is also a similar format, but you won't have an impugned order in the writ petition, correct? Because writ is a direct writ before the Supreme Court of India under Article 32. You're directly praying for something. So the prayers may be different in a writ petition. Say, for example, I'll just run through your basic writ petition. I'm just sharing you a brief of writ petition. Again, as I told you, synopsis is there, list of dates is there. Since there's no impugned order, your page number one will be your writ petition. Page number one will be your writ petition. There will be parties. I'm just running through it quickly. And then you'll have your brief facts here. In any SLP, in any civil appeal, criminal appeal, or your writ petition, brief facts is usually there as a part of that particular petition because they're coming under the original jurisdiction of the Supreme Court. Okay. And now you have your brief facts. There you'll find annexure numbers and all. Usually list of dates will contain your annexure numbers. Usually list of dates will contain your annexure numbers. In a civil appeal, criminal appeal, and a writ petition, your annexure numbers are contained in the brief facts column in a writ petition or civil or criminal appeal. Understood? And then you will have a prayer. Prayer is there in the writ petition only. So prayer is different in a writ petition. It could be the direct cases which the people are asking for. So here the prayer is there. So item 5, thing number 5 is prayer. Then I issue an appropriate direction in the nature of so and so, directing so and so to frame so and so, so and so, so. If there are 5 prayers, you'll have to mention 5 prayers. If there are 4 prayers, you'll have to mention 4 prayers. The writ is very different, so you won't have an impugned order. So what in a writ, synopsis, what you can do is, so in a writ petition, again, instead of starting an LOD column, you can write brief background. You to introduce whatever is there in the brief facts of writ petition in the brief background column. And then whether any important dates are there, you can write it. Otherwise, you can just go to the brief background and you can write a prayer. Writ petition are something most easiest tasks are done, but usually the Supreme Court doesn't ask for writ petition. So I think this is it. And apart from this, this is how a sample brief for a preparation looks like. Whatever is important is annexure number, page number is important. Locating where a particular column is very important. Delay should be highlighted. If there is a similar matter pending, listing pro forma, you have to read the annexure and then write it. Don't just rely only on list of dates. Because once if you rely only on your list of dates, because the list of dates are very short, certain advocates may not file it very properly. I mean, the questions may not also be very to the point. Sometimes what exactly happens in list of dates, the question last year also, this examiner did the same thing. 15/7/2022 was the date in your LOD column, whereas in the annexure it was 15/8/2022. It will be given wrongly to test you whether you are actually going into that particular annexure and figuring out whether the date is correct or no. So pay attention to that particular date in every annexure column. They may test you everywhere, whether you're reading every annexure properly. This is how they test you. Apart from this, I have so make apart from this, what exactly you have to do is write it properly, neatly. Use black or a blue refill pen, I mean normal pen, and then start writing it in a very legible handwriting is very important. Para page number, as I told you, and every column, every finding, every annexure you'll have to go into. And most important thing is you can brevity contains marks before Supreme Court. So brevity means making short forms. Short forms, simple short forms. TC stands for trial court. HC stands for High Court. IO stands for impugned order. But whenever you use these short forms, initially you should introduce it. So for example, challenging the High Court, you have to write it in complete High Court. Bracket me, you can write it as put it in colons, High Court, HC, so that you're introducing the particular brevity throughout the order. Without introducing a brevity in the beginning, you can't use that particular abbreviations. So you'll have to use the brevity, abbreviations on top, and then you can do your briefs in accordance. So brevity carries marks. How short? So petitioner bracket P, and then you can refer it to as P within your brief making. So these all the brevity also carries certain marks, and how concise and how to the point you are. So what exactly is very important is to read SLPs. You read at least 2 SLPs, 3 SLPs at least each day. It won't take more time. And this exam you should complete 3.5 hours is your paper 2 exam, and you should take not more than 1.5 hours for this particular question. 1.5 hours is the ideal time. 1 hour you should be able to do it, and then half an hour you should be able to figure out. Let me take you the question. Somebody's asked me, ma'am, do we also have to mention the impugned order applications at the end of the brief? The applications are not very relevant. Yes, so that's exactly what it is. It comes by practice. Sometimes they may be irrelevant annexures, so you'll be able to look at what is very important once you're able to read an SLP, where is what, then you'll be able to do it in very short time, 1.5 hours. You can't skip any facts or change of facts. It should be as mentioned. That's exactly why I keep repeating para number and page number is very important. It should be there only from what is given. You can't assume and write to your own self. Before the brief itself, after your head note is done, you can write HC means High Court, PC means Trial Court, AO means impugned order. You can give your short forms like as you wish. Certain things are there. Appendix. Appendix is usually the statute. The statutes are usually filed in appendix, but in your exam, they won't give you an appendix. You don't have to worry about it.
Ma'am, I have a question.
Hmm.
So while we are writing the facts, is it preferable if we do it like the format which you showed, like the LOD format, or the format which is uploaded on the website, like making sentences and writing dates in between the
No, it
sentences?
is in your format. You can do it in your format. I mean, you can do it in the format which I showed also. There is no specific format to follow per se. If you do an LOD column, it is even better. Recommended. Sorry, I mean, I'm unable to, I can't disclose you the SLP brief, but I can also share it through the group. I can make another brief for the same question, which is there in the part. I can send it across to you. Yeah.
Very
Interlocutory applications, you can mention what is given. Sometimes, usually, there'll be exemption for from filing impugned judgment, certified copy of the impugned judgment, exemption from filing official translation of documents. So those IAs do not make sense.
Ma'am, good evening.
Yes.
Ma'am, I had a doubt that the way you asked us to write the party name like P1, P2, if there are number of petitioners and respondent, are we supposed to write them on the top only or in
On the top, on the top, on the top. It's very important. People should know the brief making is you are making the judge understand the entire paper book in 1 or 2 pages and make sure the word limit is there 750 to 750 words is the word limit for a particular brief or 2 pages. Your brief should not go for more than 2 pages. So remember and stick to the spacing also. This is also very important.
Ma'am, ma'am,
Yes.
I had two questions basically. Firstly, while preparing for the second paper, while preparing the research memo, note making, or an SLP, so should we use while let's say if we are giving a short form, so should we define it first during our initially, like for example, if we are defining impugned order or something like that, or should we
Initially, you'll have to define it. Initially, you'll have to put it in brackets slash
yeah,
that impugned order for
yeah,
convenience slash brevity for clarity or whatsoever. You can
yeah.
just give your own
But
short forms,
should we
or you
have
can just
to,
put it in brackets and put a colon.
or should we have to write the this page number or an extra also while prepare? Yeah, page number.
Everywhere, page number, annexure number, para number. Even when you do grounds, ground A, ground B, ground C, ground D, that is also very important.
Sure, ma'am. Oh, and for the paper one, I wanted to ask that should we start from the 2015 paper of the judicial law clerk, because 23 as we know that 23 the exam pattern has changed since 2023. So should we start from the 2015 for the prelims one for paper one and
I would
like
suggest you previous year papers you can run from 2015, but this year it will be more of analytical questions. So,
yeah.
but basics you will get through from 2015 paper, start preparing.
And ma'am, from DJ for DJs also, like for DJ, since you
All, all,
told,
all papers, wherever you get relevant questions, start preparing for it. Somebody asked whether mentioning finding of district court judgment is important or only high court judgment. District court judgment finding is very, very important here. Very, very important. Any trial court, not just, there might be two courts. For example, Munchif court and then might be a district judge court and then there will be a high court. So all three court findings are very important. Whatever is there in the annexure, you'll have to write it. Whatever is there in the annexure, at least you'll be able to go through. 2 points also fine. You don't have to write if there are 30 pages of trial court order, you don't have to reproduce the 30 pages there. Even if there is 3 points which you find very valid, why the trial court came to that such finding, you'll have to mention that. Paper book will be in online format dear. Last year they gave it in an online format. So this year also they'll be giving it in an online format is what I guess. Yeah, you can use your scale stationery and everything.
Hello, ma'am.
Yes. Even whenever you go, you'll have to write your headings, impugned order, issues, everything you'll have to write.
Hello, ma'am.
Sometimes they might
Hello.
ask you a direct questions from the barracks. Yes,
Hello, ma'am.
yes.
Shivansh this side. Yes, ma'am.
Hi,
Ma'am, my question
Shivansh.
is, what is the cutoff last year the highest marks scored in the exam?
I'm sorry, dear. I'm very unaware of this. I'm so sorry. I don't know
Okay.
the cutoff mark. So somebody also asked me whether whenever the things are repeated, should I mention? No. Whenever things are repeated, you don't have to mention that. But you'll have to introduce everything. Whatever is major thing, you'll have to important. You'll have to identify and mark it.
And ma'am, one last question is that can we get any SLP case files from you if you could help, because it's getting very difficult as we have just three sample papers
Understood.
and that is,
Understood. So
yeah.
I'll tell you. I think Sambhav initiative can help you with that, with giving you paper books. I can send you a brief or a sample brief of the question given by the Supreme Court. I can make a brief and I can share it with you. But I think Sambhav initiative will be better put up to give you the sample paper books.
Right, ma'am. And ma'am, the documents you shared with us on screen, can you just share
Also, the
them with
cutoff
them?
was last year 275 to 280 last year. Okay, somebody asked me what was the cutoff, so it was 275 to 280 around. Yeah. Any other question?
Ma'am, if there are two or more parties, then we whether we have to write the whole all the parties' name, or and we can write
Yes,
another.
you'll have to write. You'll have to write all the parties' name. You'll have to write. If there are more than 20 parties, is when you guys will have a problem. But I don't think so. You guys will be given such questions in the exam.
Okay, ma'am. Ma'am, I have one more question, that whether we have to write ROP also we have to mention.
Yes, ROP is also very important. If it is an after notice matter, but I don't think so. In your exam, I don't think so. You'll get a after notice matter. If there is, then you can mention your record of proceeding. When was the notice issued?
Okay, ma'am. And ma'am, if there are interim application for the condonation of delay, so whether we have to write that.
Not very relevant here, but you'll have to mention what is the number of delay. As I told you earlier, only the number of delay is very important. Number of days in delay.
Okay, ma'am. Okay, ma'am. Thank you, ma'am. Thank you.
Anybody has any more questions?
Party
Do we make a separate section first and make a separate table for the proceedings after that, or it's your wish, dear Partita. I think you can make a separate section for prosecution case or make a separate table. It depends on you, but whenever you approach us with, I mean, criminal SLP, case of prosecution is important, period of sentence undergone is important, whether the accused is presently in jail or not should also be highlighted, apart from the other things.
Ma'am, can you please share the briefs you screen shared?
I'll share you a sample brief. I'll share it with Sambhav initiative. I think these people can send it across to you.
So thank you so much, ma'am. And on behalf of
Thank you.
Sambhav Initiative, I extend a sincere gratitude to you, ma'am, for accepting our invitation and taking the time to guide and inspire all the participants. And I would also like to extend my deepest gratitude to Patron in Chief of Sambhav Initiative, Honorable Justice C.K. Thakkar, sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Justice M.R. Shah, sir, under whose vision we were able to conduct this mentorship program. And I would also like to extend my gratitude towards Hiranshi Shah ma'am, founder of Sambhav Initiative, for giving me this opportunity to moderate today's session. Thank you so much, ma'am.
Thank you.